All right, so I think we'll get started. My name is Gilles Bissonnette. I'm a staff attorney with the New Hampshire Civil Liberties Union. I want to thank everyone for being here, students and members of the community alike. I have been told that I need to tell or ask everyone to silence their phones if they have phones, so I would urge you to do that. And as I think all of you know, this is an event and a panel on students' rights. And this is being sponsored, obviously, by the New Hampshire Civil Liberties Union as well, by the Rockefeller Center. And I could say on behalf of the Civil Liberties Union, we're so thankful that the Rockefeller Center is so gracious to host this event. I know they've also done advertising throughout the community as well. So we're very thankful that they've agreed to host this and to put it on and let the community know about it. And I do know we have even some representatives from the legislature here, Representative Olmstead here, and so we're thankful to have leaders in state government here as well. Real quick, because I think this is important, I want to give a quick plug for the ACLU and the New Hampshire Civil Liberties Union. This event is, in addition to being an event to help educate students about broadly their rights, is also coinciding with a membership meeting. And I hope some of the individuals in the audience are also members of the ACLU. For those of you who don't know what the ACLU is, it stands for the American Civil Liberties Union. As I said before, I'm the staff attorney for the New Hampshire Civil Liberties Union, which is the affiliate, the New Hampshire affiliate for the ACLU. And we're the largest and longest serving civil liberties organization in the United States. And the genesis of the ACLU goes all the way back to around the early 1920s following the Red Scare in post-World War I America. So we have such a long history protecting civil liberties in the United States. Currently, there's over 200 ACLU lawyers practicing in the United States. That includes not just at ACLU National, but it includes having lawyers on the ground in all 50 states. And one of the great, I think, tidbits about the ACLU is aside from the United States government, the ACLU has argued more cases before the United States Supreme Court than any other organization. And that, again, goes all the way back to the 1920s. And includes even some recent successes with the E.D. Windsor case, challenging the Defense of Marriage Act. And so not only, of course, are we active nationally, we're active in New Hampshire. And in fact, in the past year alone, the ACLU has argued 6 cases before the New Hampshire Supreme Court. So the way I like to put it, we're everywhere. And I think that's great and the way it should be. And part of what the ACLU does is sponsor events for the community, educate people about their rights, and that's really the focus of this event today. And I'm so grateful and thankful that we have what I have described as an all-star panel who are going to be able to talk about some really important student rights issues, including some student rights issues that Dartmouth is facing. Dartmouth's been in the news during the past year about, I think, a lot of issues that we all know about, and we're going to touch upon some of them. So as I said before, this panel is about student rights, and we're going to cover 3 subject matters. And the first is to what extent constitutional rights apply in the school discipline process. So we're going to talk a little bit about fundamental fairness. We're going to talk a little bit about mechanically how the school discipline process works, especially at private institutions, what constraints exist on private institutions as they're crafting student discipline policies, and we're going to talk about the genesis of some of those policies. There have been some recent developments and events that have caused private universities to change their policies. We'll talk a little bit about that. We'll also talk about what rights do university students have in their interactions with campus police and law enforcement. And finally, we're going to touch upon what rights do students have to their personal data being collected by colleges and universities. And one of the topics that I hope the panel gets to address is what rights do students have to keep data and information from their parents. So it's a topic that I would really like to know more about as well, and I know our panel has some expertise on those subject matters. So without further ado, I would like to introduce our panelists. I'm going to go from your right to your left. So our first panelist is Judith Sizer. She's practiced as a higher education lawyer for over 25 years. Before joining Rose, Chinitz and Rose, she served as senior vice president and general counsel at Brandeis University in Waltham, Massachusetts. and she's spoken on higher education law issues at numerous conferences. We also have George Ostler to Judith's right. He has 30 years of experience defending persons accused of crimes in both state and federal courts in New Hampshire and Vermont. He was employed by the New Hampshire Public Defender Program from 1983 to 1994, and he's been a partner at DesMeules, Olmstead, and Ostler since 1994. And we also have Leah Plunkett to George's right. She's the Director of Academic Success and Associate Professor of Legal Skills at UNH School of Law. She's a fellow at the Berkman Center for Internet and Society at Harvard, where she works on the Student Privacy Initiative, and she founded the Youth Law Project at New Hampshire Legal Assistance. I'm thankful that she founded that project. The ACLU collaborates a lot with NHLA and the Youth Law Project. We also have Chris McLaughlin. Chris has over 25 years of experience prosecuting and defending criminal cases. He began his legal career with the New Hampshire Public Defender Program in 1988, was in private practice for 4 years before returning to the program. And starting in 2006, he served as Assistant County Attorney in Cheshire County, and in 2013, he took over his current position as Cheshire County Attorney. So with that, let's just give them a round of applause, thanking them for being here. And so let's get to the first topic, which is the school discipline process, and just generally how that works. And I think, one of the things I'd like the panel to address is maybe some misconceptions that maybe we have about the school discipline process at universities. Because I would assume that most of the students here haven't gone through that process. I hope that's the case. And so I want to start the panel off with George, who's represented some individuals who've gone through that process. If he can maybe explain a little bit about what that process looks like, and then we're going to get into some issues concerning fundamental fairness and the nexus between this process and constitutional rights. So I'm going to pass it off to you, George, to talk about those issues.
I'll talk to how the Dartmouth and how private colleges and university systems work, because that's the fundamental distinction people have to appreciate, that the Bill of Rights, which governs how an accused is treated by society and the courts, doesn't apply to private universities. It doesn't apply to private people. The Constitution, the Bill of Rights, applies to state actors, of which private colleges aren't. So right off, the main engines of truth and reliability that have developed for hundreds of years that we see in our court systems are not applicable to this disciplinary process, and such things as right to be represented by an attorney, right to cross-examine, right to have the evidence governed by established rules, and the right to have an appeal by a disinterested entity. None of those things exist at the college level. The college level, the private college level, it's really a contractual situation in that the practice is governed by the student handbook and by the policies generated by the private college. There have been, over the years, challenges to Dartmouth systems, Dartmouth's process, people trying to get an injunction after the student was thrown out of those kind of things. And time after time, the courts really say, this is a private relationship that's really governed by consent, and long as there's some fairness, some process, the courts aren't going to get involved. So it's really, to start with, a contractual situation, and I'll just take you through how the process has worked. There are going to be changes with sexual assault, and I'm not totally familiar how that's going to work yet, but in the normal case, if there's a disciplinary issue at Dartmouth, there's an initial triage done by the judicial affairs officer, whether or not the conduct is sufficiently serious to perhaps warrant a suspension. If it's minor enough that college discipline or probation is the only possible sanction, then that's handled by the judicial affairs officer one-on-one with the student. However, if in this initial determination is made that the conduct is more serious, that might warrant a suspension, then it's referred to the Committee on Standards. And they have a process by which the Judicial Affairs Office creates a list of charges and which college standards, and again, the college has a handbook on student standards and they will cite specifically to what standards they might be there. That's given to the student. The student either admits or denies. If he denies the allegations, then the next step, there's a somewhat of an information sharing step that goes on, that the college, through their judicial affairs office, will give the student whatever information they've gathered. The student's under an obligation to identify witnesses and give the statements to the panel. The panel, COS then puts together a kind of a booklet of all this material, and then they convene a hearing. The hearing is presided over by a dean, who is the combination of court clerk and judge, non-voting, but runs the show. The panel themselves, it's two faculty, 2 students, and 1 administrator are the 5 people, and they then hear the case. Now, a student and that has no right to an attorney. The student has a right to have an advisor, who has to either be a student, faculty member, or a member of the administration. That advisor gets to sit with the student during the hearing, but cannot take an active role, besides maybe passing the student a note or whispering in their ear during the break or something. But the student's on their own. And it's really much more of an inquisition than a trial. It goes on, the 5 members can pose questions as they see fit. The dean regulates it somewhat. The student cannot directly ask anybody any questions. He can suggest questions to the chair, and then the chair can relate the question. In the past, they seem to vary about how strong the requirement is for live witnesses. Sometimes they can require live witnesses, but now that New Hampshire has kind of freed up their Freedom of Information Act, if the committee gets their hands on police reports, if the police were involved in the investigation, they often are just handed out and without further witnesses being called. So it's a summary proceeding where the student again is really on his or her own, with really limited ability to during the hearing to consult with anyone. And then after the evidence is heard, they deliberate. The next day, the student gets the word, what happened. The COS, the panel, also imposes the sanction. And when that happens, then the only appeal is a written appeal for errors in procedure or newly discovered evidence that goes back to the dean who sat on the case. And that's the disciplinary proceeding.
And what, George, if you don't mind, what's the standard, what's the burden of proof? Is it preponderance of the evidence?
Yeah.
And so maybe you can tell the audience a little bit about the 3 various standards of proof and how they vary.
Yeah, the law recognizes there's 3 standards of proof that have been developed. The lowest is preponderance of the evidence, which is used in most civil cases in our courts. That's really like 51%, more likely than not. In criminal cases, the standard is proof beyond a reasonable doubt. And now there's been an intermediate standard that's been developed largely by the courts, and some legislatures have enacted to. It's by clear and convincing evidence is the intermediate standard.
Great.
And the college uses the preponderance of evidence standard.
Great, thanks, George. And so the next question, and I'm gonna pass this to Judith, is to what extent do those policies that George articulated are now being altered with respect to sexual assault cases? And then I'd like to talk a little bit about what is motivating those particular changes. So Judith, what are the changes that are being made both here in Dartmouth and nationally?
Well, as George said, at private institutions, state law generally governs the way these procedures work. And as he said, the courts have generally been very deferential to private institutions in how they set up their disciplinary processes. The leading case in Massachusetts is actually a Brandeis case. But there has been an enormous amount of interest in Title IX, and specifically sexual violence cases under Title IX, starting in the spring of 2011, and it's been heating up ever since. And the Assistant Secretary of the Office of Civil Rights of the Department of Education was here at Dartmouth on Monday and told people at the Dartmouth Summit on Sexual Violence that she had used 4 times in the last 10 months, which is how long she's been in that position. 4 times she had used the threat that all federal funding would be taken away from a private institution if that institution didn't comply with the OCR's version of procedures for handling sexual assault cases. So that's sort of an overlay of federal agency guidance law over the state law in these sorts of cases at private institutions. And I can tell you from my experience as a university lawyer, this is the topic right now because colleges are scrambling to look at their procedures and think about how they're handling things. There's an enormous amount of interest in changes to the actual process that's being used for sexual assault cases, and I think Dartmouth's process may change. There's a lot of, first of all, the guidance in 2011 said that colleges must use preponderance of the evidence in these cases, that clear and convincing, which many were using, would not fly. So preponderance had to be the standard. Then there was a concern about cross-examination of accusers, that could be harmful to them. So there was a lot of push about finding another way to get at the facts without having a cross-examination type process for the accuser. And, you know, and beyond just the particular procedural issues is an enormous amount of attention now on programs in training and education, and particularly bystander intervention. That's something that's gotten a lot of attention, is training students to intervene before an assault might happen. Now, the president is very interested in this. He's hosted several summits on this. He is, over the OCR. And then Senator McCaskill in the Senate has been putting an enormous amount of attention on this. She was very interested in sexual assault in the military, and she's moved on to this issue. She's hosted a number of listening tour type conferences. She sent out a survey to 450 colleges asking them what they did. And she just published the results of what she found. And she's going to propose legislation. What she says will be an intermediate sanction, so something that's in between what the OCR can do in sort of embarrassing institutions and what it can do in taking their federal funding, but something in the middle that might be a useful tool. Now, the Assistant Secretary has said that she isn't sure that's necessary, but so right now we have this, I mean, you can't pick up a newspaper right now. The front page of the Sunday Times was about this, and from the government perspective, they are the most interested in the accusers. They're worried about victims. They don't seem to pay too much attention to what's happening to the accused. That's where they're heading right now. Now, the pendulum may swing and they may, start being a little more even-handed about it, but that is clearly where they're heading right now. So again, the state law and the deference of the courts to private institutions in how they do this is one thing, but when the federal government starts making all this noise, you really have to pay attention.
And I think it's interesting because, most folks would probably think that private institutions can kind of do what they want, and they're kind of on their own, they're on an island. But here you have a situation now where the government is saying, well, we can use kind of Title IX as a sword to kind of get private institutions to essentially do what we think's best. And there's legitimate concerns, I think many people would argue on the part of the government that some changes need to be made because victims may not report incidents of sexual assault if they're worried about being cross-examined. Sexual assault is a crime that's traditionally not underreported. And so, Judith, one of the things I'm interested in is maybe you could explain to the audience a little bit about what Title IX is, because some people may not.
Well,
be
Title
familiar
IX,
with what that is.
if you're as old as I am, you think of Title IX as about equity and gender equity in athletics, because that's where it really started. I mean, that's whatever. But it was basically discovered as a tool only a few years ago. I think it was with this initial guidance in April of 2011, the OCR decided that they wanted to use it more effectively, in their view, to combat this sort of, and it's about making sure that the opportunities, educational opportunities at institutions that receive federal funding are equal for each gender. And the position, the way they feel is that if one gender feels that the educational environment isn't as welcoming, then that's a violation of Title IX. And so I mean, it's a very vague statute. Just, you know, the actual statute sounds pretty vague. So this is where they're going with it. And, you know, they've come up with guidance, they've come up with Q's and A's. The White House has been behind some of this. There could be legislation down the road. But their entry into private institutions is this federal money. And it's federal financial aid money, it's federal research money. It's also how FERPA.
Yeah.
So there's
which we'll talk about.
Which we'll talk about, which is student privacy law. That whole regulatory scheme comes in because of federal money. If an institution said no to federal money, it wouldn't have to worry about any of these things, but virtually none of them say no. A few of them do for religious reasons, and so they don't need a lot of lawyers. But all the others, I mean, that's how it comes in, and basically you're not going to say no to federal funding. I mean, it's an enormous amount of the budget for most of these institutions.
If they lose
so,
essentially to death
yeah,
sentence
no,
if
I mean,
they lose federal funding.
You have to have an enormous amount of private money
Yeah.
to keep an institution floating without it. And so, you know, that's why their university lawyers have to worry about it.
One last question for you, Judith. Can you explain kind of the specific changes that Dartmouth has made and that DOJ is asking? I know there's kind of two big changes with respect to the investigatory model and with respect to sanctions for those folks who are found to have committed sexual assault. So I don't know if you could just...
Well, you may know more about this than I do. There has been a movement towards an investigatory model because of the fear of re-traumatization of the accuser. So in that model, which more and more institutions have adopted, an outside investigator, generally with legal training, interviews all of the people involved, the accuser, the accused, witnesses, and does it separately so that there's no confrontation. And then the investigator comes up with a report of the facts, which is then presented to the institution and reviewed in various ways. It varies. Now, I don't know if that's what Dartmouth...
I think that's what they're talking about. I mean, related with that, one thing that Dartmouth has had pretty much a tradition, although there's some exceptions, of if there's a parallel criminal case going on, that Dartmouth would agree not to adjudicate their disciplinary case until the court case is done, because it puts the student, of course, in a whipsaws the student, that the student's got a Fifth Amendment right not to speak and to give information that might incriminate him. So until the criminal case is done. So in most cases, the college would wait until the criminal case is done. They are not going to do that with the sexual assault cases. The sexual assault cases are, is my understanding, are going to go full steam ahead, and they're not going to wait for the adjudication of a criminal case, which of course, from an accused point of view, is a disaster. The accused may have to decide whether or not to try to defend himself in the college case, or because if he's got a lawyer, and any lawyer is going to tell him until a criminal case is done, you just can't say anything to anybody. And so that's going to be exactly how that plays out. I don't know, but I know from a person like myself who is involved in the criminal justice system, that is a drastic change that we're going to have to, it makes things very, very difficult.
Chris, could you talk a little bit about that too, that kind of the nexus between simultaneous school discipline proceedings and criminal actions, and how kind of that process works? Keene State's in your jurisdiction.
Right. So at Keene State, generally what happens, Keene State, the campus safety is very similar to Dartmouth's campus safety, in the sense that they're really just employees of the college. They're not sworn law enforcement, so they don't carry guns. They have no power to arrest. They have no power to seize contraband or evidence. So what will typically happen at Keene State is, if there's a criminal act, they would notify, the campus safety would notify the local Keene Police Department, who would then come in and conduct their investigation. From the Keene Police Department's perspective, They really don't care about the college disciplinary proceeding. What they care about is investigating the criminal act, gathering the evidence about the criminal act, interviewing witnesses, and putting together the criminal case. So they're going to go full steam ahead, irrespective of what's going on in the criminal judicial setting. So, the prosecution essentially just doesn't work with the Keene campus safety in the sense that it's kind of a joint investigation. The prosecution does their investigation, and at the same time, Keene State may be running a parallel investigation for purpose of their judicial proceeding at the school.
All right, thanks, Chris. Let's go back. Yeah, so actually, I forgot to mention this, but we're going to finish up at around 5:35, and we're going to allocate about 10 minutes for questions. I want to go back a little bit more to the investigatory model. And am I right in that there's not even a hearing in that model, right? So the investigator goes kind of person to person, witness to witness, interviews the complainant, interviews the individual who's been accused, and a report's issued, a finding is issued. Am I right on that?
Well, actually, the report is issued, it's supposed to be just the facts.
Okay.
It's not supposed to express an opinion as
Okay.
to whether any policy was violated. That, it has to be made very clear to the investigator that that is his or her role.
Okay.
And then the college takes it from there. But another aspect that I believe Dartmouth has accepted is mandatory expulsion.
That's right.
Isn't that right?
That's
So-
right. For penetrative sexual assault.
Right.
Yeah.
And that's something that Dartmouth is one of the first institutions to do that.
Interesting.
And several other institutions have gotten a lot of criticism for not doing that. Williams has been dealing with quite a scene about a case like that. But it's a difficult issue.
Yeah, so it's interesting. So George was talking a little bit about the hearing process itself and how there may be fairness issues, and under the investigatory model, I mean, there isn't even a hearing, let alone one that may have some flaws that some people would argue exist. So that kind of goes into the next question, which is it fair, right? And also there has been some litigation. I'd be interested in how this kind of dovetails with the Share case, where the appeals court actually said that fundamental fairness should be kind of imputed, to these proceedings, even when dealing with the private school. And so I'll kind of pass this to maybe George and Judith about their opinions, concerning fairness and whether or not anyone has any. Could someone even challenge this? I don't know. After they go through this process.
Well, in the past, their challenges haven't been very successful, but one thing that you're seeing with this is when a student gets expelled from a school like Dartmouth, that's probably his academic or his career is probably over. No one's going to touch him. So on the one hand, you can, the kind of classical deference of the courts that this is a private matter between these schools, as long as there's some fairness, we're not going to do anything. That's the only hope because the consequences are so drastic. And there's no question, it's very, very disturbing from someone like myself who's been involved in the court system. We have, the methodology and the rules that we've developed over hundreds of years to test evidence, to make sure it's reliable when serious things happen, such as cross-examination and a right to be represented by a lawyer, and those kind of things. They are totally discounted. There's a certain arrogance to the system that we can now create a better system. We're going to streamline it. We don't have to, and I don't know if arrogance is the right word, but that's how it appears to me, because there's a kind of feeling the courts are way too involved and they're too slow, and guilty people get off, and we're going to do it better. And that's really the model they've gone to. And mistakes are made all the time, and really the question becomes, how many mistakes, how much collateral damage can you tolerate in this streamlined system? Because you're going to have them. We know, you have them anyways, and in this streamlined system, you're going to have even more. And how much can we tolerate? Because as soon as a kid gets thrown out for this, his academic career is over. So, I mean, that's going to be the evolution of it. And from someone, from my point of view, it's very disturbing. It's not clear what exactly we can do about it, but that's my perspective.
And one of the interesting issues is, does Dartmouth even have a choice? Right, and it sounds like they may not. And
Well,
so I'll dump that back to you, Judith.
Well, it will be very interesting to see a case that arises after all this Title IX, and how much the university will use Title IX as a defense, essentially. But the Share case happened, it started in '96 and ended in 2000, and it's procedurally a little quirky, and I won't bore you with it, but basically, unless you feel like it. But the appeals court, the case got dismissed at the earliest possible moment. The appeals court basically said, no, go back and start again.
And it was a student who was challenging a school
Well, it was actually
disciplinary
a sexual assault
Yep.
case, and it was a middle of the night, alcohol involved, he said, she said case. Classic. So the trial court dismisses it at the first possible moment. Doesn't even, no discovery, no nothing. Goes to the appeals court. The appeals court says, not so fast, send it back, because behavioral issues like this are basically the bread and butter of the criminal courts. Courts know how to handle these issues. So the traditional deference to private education shouldn't really apply in this context. You can have the academic cases and the plagiarism cases. I mean, the court shouldn't go near those. But this is essentially a rape, said the appeals court. And we know how to do that, so the court shouldn't defer to that. The court should scrutinize what these institutions do. So that ruling came down, and it was Brandeis appealed it to the highest court, and we had amicus briefs on both sides. One was the ACLU,
did one.
Harvey Silverglate, my pal, and the other side was 10 Massachusetts private universities. And then, so it was argued, and it was a little hair-raising, because the SJC is normally 7 justices, and it was down to 5 for various reasons, and the Chief Justice was the Honorable Margaret Marshall, who was famous for the gay marriage decision, and she had been the general counsel of Harvard before she went on the bench, and she could be relied upon to understand these issues. So it was, kind of an interesting case to pitch to her. But the SJC ruled 3-2 to uphold the trial court. So it overturned the appeals court's opinion, and the opinion is very much about deference to private institutions, and it's a very strict reading of the student handbook at Brandeis, and was it followed word for word, with 2 quite angry dissents, saying no, this isn't right. So it was a very close decision, and it was just on this issue of how much should the courts get involved with the sorts of behavioral problems that it deals with every day. So, and that issue is, obviously still with us today. But in the Title IX context, there's often a lot of discussion about what the institution does when the local criminal authorities won't take the case. And it can't stop there at the institution. I mean, Title IX won't let it. So basically, when the prosecutors or whoever's consulted about it doesn't think it's a strong case from a criminal perspective, what then does the institution do? And that's a dilemma for, either the accuser doesn't want to go talk to the police, or maybe if he or she does, then the police don't take it, and Title IX or the OCR is very clear that the institution can't stop there.
Interesting. Any other comments about kind of the fairness of this new process? I know if someone from Dartmouth were on the panel, and I could quote the dean, would say, what we hope the system will result in is an increased confidence in the way we adjudicate these cases and increased credibility around the system, all of which feed into creating a community, harping on the notion that these procedures are needed to increase confidence on the part of students that they are learning in an environment that is safe and not hostile. I don't know if there are any other comments on that, but I certainly want that perspective to be out there, and that's certainly the perspective of the Office of Civil Rights. All right, so that we were way over. I want to get on to my second topic. which is, and we've talked a little bit about it, the criminal process as it relates to universities. And one of the questions I had, and it goes back to the issues that we talked about before, is to what extent can school discipline proceedings and the facts that come out during that process be used in a criminal investigation later on? So Chris, I'll maybe dump that question to you. Are they severed, or can they kind of blend and maybe to the disadvantage of a defendant?
Yeah, we really do not get involved in trying to gather any information that takes place during a Keene State College, judicial determination of whether the student's going to be suspended or expelled. Those proceedings, we've never really pushed the issue and tried to get information from those proceedings to see if anybody's testified at them, to see if those proceedings are even recorded. I think FERPA, which we'll talk about later, would act as a roadblock at some level to us just being able to access that information. So we really don't rely on any information that comes out of those proceedings. Having said that, I'll often hear from defense counsel, hey, by the way, your alleged victim at the college disciplinary proceeding said something much different than what she told your police officer. So that, in and of itself, can present a problem for my case. So, but we really don't get involved in using any information from those proceedings in the course of the criminal prosecution.
And George, does that impact your decision or the advice you give to clients?
Absolutely. I agree with what Chris said, but from there's nothing as such in the first instance privileged about what anybody says at a disciplinary hearing. And I've seen in Grafton County on one occasion, it was involving it was a disciplinary proceeding involving a Greek organization where the prosecutors in Grafton County went to the grand jury and got a subpoena for the recording. And the case ended up resolving, and so the issue was never resolved whether or not they could use it in court, but they got the recording through the grand jury subpoena. So clearly, I think the law would, as to statements, not records, but as to statements that people made at those proceedings, I think they're probably discoverable through a grand jury subpoena and probably admissible in court. So
interesting.
Yeah.
So even though it's not being sought, there's always that concern as defense counsel. It's out there, and you need to give advice accordingly.
The run-of-the-mill case, the prosecutors probably aren't going to go to the trouble doing that, but if under certain facts, they will, and they probably can.
So I want to now segue a little bit to searches and seizures. More broadly, what can law enforcement and campus police do on campus with respect to coming into dorm rooms? And obviously there's a distinction here between private universities and public universities. And so maybe, George, I'm gonna dump this one to you to talk about a little bit what the Fourth Amendment means and what the general rules are with respect to universities and colleges.
Fourth Amendment doesn't mean much.
Unless you have a cell phone, which we learned.
No, as to private, as the Dartmouth Safety and Security, the Dartmouth students are put in a very, very tough position. And why? I mean, again, the Bill of Rights, the Fourth Amendment applies only to state actors. And Dartmouth Safety and Security, they're not sworn officers and they're not state actors. I mean, our professional point of view think they're agents of the state, but we haven't prevailed on that one yet. But it's very difficult. The students are supposed to cooperate with safety and security. And what is happening now a lot is safety and security perhaps will go by a open dormitory window and people are smoking marijuana in there, or there'll be a complaint that so-and-so's hallway smells like marijuana. Safety security goes there, knocks on the door, steps inside and says, you guys are smoking pot, give us a pot. And safety and security takes the pot, takes it back to their offices, calls the police and says, we seized this marijuana at room so-and-so, and then the police either get a subpoena or a search warrant for the reports, because the safety and security does some follow-up interviews, and they write it up on their reports. And so the police get a warrant, or they can get it through a grand jury subpoena, and they get the reports, and they've got this criminal case packaged up. Here's the marijuana, here's the report, they've done everything except test it. I mean, they've done the chain of custody. It drives us crazy. Because, see, from a student's point of view, what's so tough about it is they have no privacy rights as to safety and security. A police officer could not do a lot of the same conduct, because under the Fourth Amendment, if they're private areas, the police officer can't go there and seize evidence without a warrant. They can't enter students' rooms without warrants. So what we see happen, and it happens a lot, and so from a student's point of view, that puts them in a position that if they don't cooperate with the safety and security people, they might open themselves up to a disciplinary hearing. If they do, sure enough, the police get the reports, they go get a warrant, and the criminal case is brought. So it's that's from the private university, the students are sometimes, it's the worst of all worlds.
And before I pass it to Chris, one of the points you're raising, I suspect, is to the extent that students have any rights with respect to searches and seizures vis-a-vis private institutions, they are rights that are a creature of contract or a creature of university policy, right? So Chris, what are your thoughts on kind of searches and seizures and how they operate in your practice?
Sure. Interestingly, the security officer at Dartmouth is no more authorized to possess that marijuana than the student is. So I'm not sure how he's getting away with taking it from the dorm room to the. But there must be some internal agreement between the chief of Hanover Police and campus security. But for that very reason, at Keene State, it operates a little bit differently. Keene State, Keene Police has a service agreement with the college, and essentially what the service agreement is that the police department provides the college with one college liaison officer who has a small office and a computer down at the college, and he or she goes down there usually Wednesday, Thursday, Friday, and Saturday nights, and is on call down there. So what happens at Keene State is they will, the typical situation, the RA or campus security smells marijuana, they'll just pick up the phone and call that liaison officer who will go and handle it, or call in reinforcements from the Keene Police Department to come in and conduct the investigation. What happens in that case is they show up, they smell marijuana, they are required to either get a warrant, or there's certain exceptions to the warrant requirement. One of them is consent. So they can ask the student, can we come in? And the student, can say yes or can say no. If the student says no, then they'll generally just stand by. They'll tell the student to come out of the room, put an officer on the door, and then they'll hopefully have enough probable cause developed so that they can draft a warrant, take it to a judge, and see if the judge will grant them a search warrant to go back to the room and search the room. So it operates a little bit differently at Keene State. I don't think it's necessarily because it's a state university. It might be. I think one of the interesting things about Keene State is that the security officers are, they're employees of the college. They're not sworn law enforcement. So I'm not sure that, them conducting a search unrelated to a criminal investigation would necessarily constitute state action for purposes of a constitutional analysis. So in other words, I think campus security will sometimes go into rooms to check on safety issues and things of that nature. But in that capacity, they're really not acting as quasi-law enforcement. So.
Great. So the last question on searches and seizures has to do with student housing agreements, and to what extent a contractual relationship between a student and his or her university allowing university officials to come into their room can kind of be used as essentially an excuse or provide permission for law enforcement to actually come in and actually conduct a search. So, Chris, I'll kind of pass that back to you because there's some case law on this. Yeah,
I think there's a case out of California where they tried to argue that the university essentially, the campus safety officer consented to the local police to search the student's room. And they tried to argue that that was third-party consent because of the student housing contract that was entered into between the student and the university. So, there's marijuana discovered in the room by campus safety. They then call up the local police, say, come to the room. Local police enter the room without a warrant with the permission of the campus safety. And what they tried to argue is because of this housing contract, essentially the student has given us authority to consent to have other parties enter the room, and the court said no. There's no way that essentially a landlord, they analogized it to a landlord cannot consent to have the police search his or her tenant's apartment. So the housing contracts, I don't think give campus safety any sort of reason to allow consent to search. So,
Anyone else on this?
Well, I think it's, on this issue, at least in New Hampshire, it's still, in 2002, we challenged the action that I talked about, and the local court found, see, if the safety and security are agents of the police, then they're state actors for the Fourth Amendment. And we actually convinced the local judge that the safety and security was acting as an agent, and they found the search to be unlawful. And then the state appealed, and we lost in front of the state Supreme Court. But the state Supreme Court came up with this curious kind of notion that the college was actually just enforcing their own interests and removing the marijuana from the room, not state interest.
That is the educational interest.
Yeah, that's what they found, even though they were like handing it over, But I think as we go on and now you see more and more consequence. I mean, in the Google age that we have, that more and more consequences coming out of these kind of things that I think hopefully they'll get revisited sometime, because I think they're wrong,
right.
And that's hopefully something will get changed.
So the last topic, I'm going to segue now to student privacy, and I would love to get Leah's take on this, as she's an expert on some of these issues. And so my question to you, Leah, is what kind of information do schools collect on their students, and what protections may exist in the law to ensure that student privacy is protected?
So at this point, schools K through 12 as well as higher ed, and we're obviously focusing today on higher ed, are collecting vast amounts of data about students. We're in the big data age. Actually, George was just alluding to that. And the data is being collected by a variety of different folks, depending on the school, and used for a variety of different reasons. To just give a couple of examples, more and more teachers, and I'm one of them, are experimenting with new educational technologies in the classroom. There's a tool that I really like called Socrative that allows you to have people in a room physically log into a virtual room online and answer questions in real time, either multiple choice or short answer, and then the results pop up on the screen. And it's a really cool tool for an educator to use. I've used it successfully in a couple of contexts. At the end of it, if I wanted to, I could save a spreadsheet of all the results, and I could use that to help plan my lessons, let's say. Or if I was at a school that had very sophisticated learning analytics capabilities or software programs, I could feed those data points into my learning analytics tools and try to put together profiles of the students in my class to see, how quickly they can answer questions, how often do they get them right, and put together, in some contexts, very sophisticated portfolios that could help me as an educator who's in front of the room tweak my lesson plans, for instance. So that's one example. Another example is that administrators, which I also am, use a whole variety of learning management systems and student information systems to manage data. So students in the room, think about every time you swipe your ID card. That is sending a signal about what building you're going into. It's sending a signal about what food you're buying. I assume Dartmouth, like most schools at this point, you can link money to those cards. So you're making purchases at the bookstore or somewhere else. That is all being aggregated. And I don't mean to make it sound scary or nefarious. I truly don't believe it is. But the inevitable result of big data is, as a recent report by the President's Council of Advisors on Science and Technology found is that we have more and more data being generated by all of our interactions. Schools are no exception. And a lot of the value in big data is running analytics on it. So for instance, and I don't know if Dartmouth is doing this, but I know some other higher ed institutions are using some of that swipe card data in kind of an urban planning style way. So gosh, if we have a lot of folks using this library but not that one, maybe we should reallocate our staffing decisions and close that library and open the other one. Or maybe we should put a student center over here and not over there. So again, I really do believe that, and maybe this is self-serving as an educator, as an administrator, but the folks who are doing this are doing it with the best of intentions. But it does mean that you are leaving as a student a vast amount of digital information about yourself, a lot of which you might have no idea about. Now, you asked about what protections exist. So the sort of strongest source of protection for student information, someone mentioned earlier, is FERPA, Family Education Rights and Privacy Act. It was passed in the 1970s, and that applies to Dartmouth or any other institution receiving federal funds, which, as Judith said, is most institutions of learning in this country. And painting with a broad brush here, student education records cannot be disclosed outside of that institution without the consent of the student, if the student is 18, or of the student's parent, if the student is younger. So essentially, FERPA says you have to tell parents, or in the case of Dartmouth and other higher ed institution students, what information is being disclosed, to whom, and for what purpose, and give them the opportunity to consent or not. There are a couple of exceptions to that rule, and the one that often comes into play in data privacy is called the legitimate school official exception. So if Dartmouth or any other institution is outsourcing something that would otherwise be done in-house, so let's say it's contracting with a private company, and I have no idea if Dartmouth is doing this, it's a hypothetical. I'm a law professor, we like hypotheticals. And saying, okay, we don't have the capacity in-house to figure out who's buying French fries and who's buying kale, but we have a great third-party software provider that's going to aggregate this information for us. We're just going to contract with them to use their software, and they're just going to hold our students' dining hall purchases in their database, and we can access it and run analytics on it and make decisions about it, but we are actually having a private company hold on to this information for us and have some access to it. Well, if Dartmouth or whatever school is doing this is outsourcing for a reason that would otherwise be done in-house, and that company is under the direct control of Dartmouth, and that company is not resharing the data, then students don't need to be given the opportunity to consent to it. In other words, Dartmouth can just do that. But they should still be given notice that it's happening and an opportunity to opt out. And I will say one of the really difficult things in the realm of student data privacy right now is, again, even with the best of intentions, a lot of student data is kind of going down a rabbit hole. In other words, I was talking about this recent report by the President's Council of Advisors on Science and Technology, and they actually said in the report, it's funny, they said it was a fantasy land, quote unquote, direct quote, to think that people are actually reading privacy policies before they use products. And unfortunately, that's sometimes true of administrators and educators. I know this is not something that university lawyers like to hear, but it's true. And so, Dartmouth or my hypothetical school may well be sending this information to a private company, and somewhere in that fine print, the private company is saying, we're going to use this information for marketing purposes. We're going to resell this information. And that should not be happening, but unfortunately a lot of data, I guess, suggests that it is in certain contexts.
That's interesting. So this is back to you, Leah, and you, Judith. What are some of the myths around FERPA and some of the myths that students may believe with respect to how private their information can be, and in particular, what their parents can find out with or without their consent?
So many institutions tell their students that they will not disclose any information to parents without a consent from the student, and that's required by FERPA, but that is not true. FERPA allows institutions, and I should say allows them, doesn't require them, allows them to share education records with parents of a student who is a tax dependent. So that's the criterion, and if the institution knows that the student is a tax dependent, and most undergraduates are, especially at a place like Dartmouth or Brandeis or any of the, then this, as I said, the institution can. It won't get in trouble with DOE if it does, but it doesn't have to. And sometimes some institutions have found the consent requirement a way to keep helicopter parents away. I can't tell you about that. You know, you have to go get your child to consent, you know. But if the fact of the matter is that if a student is in distress and the school really strongly believes that the parents need to know about it, then they can tell the parents without the student's consent. Now, most of them will do backflips to try to get the student to tell the parents. But the law does allow it. There's also a health and safety exception that can be used if the school is that worried about the student. Then the institution can call the parents. And there's usually a philosophy, if a student affairs department understands this about FERPA, they usually develop a philosophy about when to call the parents and when not to call the parents, and a lot of it depends on the relationship between the student and the parents. And a lot of it depends on what it is that is troubling the administrators. Is it a freshman who hasn't left her room in a week? That's a problem. Is it a senior who just got a C on a paper? That is not a problem. I mean, it's sort of that sort of determination. But yes, it's a very widely held myth about FERPA. There are many of them.
Any other comments before we go to questions? All right, well, we covered a lot in an hour, and if there are any questions from the audience, I know the panelists would be happy to answer them. Right here.
What are the consequences to a student?
Oh, I'm sorry, we have a mic, and I think that's because this is being filmed and will actually be on the Dartmouth website as well, so if that's okay with everyone.
Yeah.
Do I need my parents' permission? What are the consequences to a person who is participating in a judiciary hearing? For example, a person who's been accused of a crime of some sort or an infraction. What are the consequences for that person if they don't tell the truth?
At the college level, you mean?
Yes.
I think there's no legal consequences. It's not a sworn proceeding, so it doesn't involve perjury or obstruction of justice or anything like that. But I have seen, and I believe that if the disciplinary panel thinks the person is lying, they'll hold it against them. But outside of that, because I guess theoretically they could convene another disciplinary panel because that's part of the student code that anybody who appears before the COS is expected to tell the truth. So theoretically, they could file another set of charges that, from the disciplinary point of view, but there's no legal consequences.
Right there, yep. In front, gray shirt. Oh, you need the microphone, sorry.
Thank you. If an alleged rape is reported to the police department, does the police department then become the chief investigated agency, or do they act in concert with the college? How does that work? How do they work together, or do they even work together in those instances?
The police department is the chief investigation agency, and they don't work with particularly in Keene, with Keene campus safety. So they'll essentially, if it gets reported to the police, it's their investigation. They'll conduct it. They won't consult with Keene campus safety. I mean, unless a campus safety officer might be a witness at some level, they'll talk to him or her. But it's the police department that does the investigation. And sometimes what happens, and it can be problematic, is the victim will report to somebody who's wearing a uniform and looks for all intents and purposes like a police officer, and it's campus safety, and for whatever reason campus safety doesn't then relay that information or that accusation to the police department. I mean, we've had a case where a father called up the Keene Police Department and said, what's going on with the sexual assault case against my daughter, and the police were like, what sexual assault case? So the daughter reported it to campus safety, and for whatever reason, campus safety didn't report it to the Keene police, and from a student's perspective, when they're talking to the campus police or campus safety, they think they're talking to law enforcement.
Can I ask one more question? In the case of rape, is there any consensus on the meaning and the definition of the word consent?
That was one of the changes that was recently made by Dartmouth, if I'm not mistaken. Does anyone have any?
I mean, I've actually done a little academic writing about this, so I can't speak to it as a practitioner or a prosecutor could, and hopefully they'll weigh in. But there's a wide range of definitions of consent that are used in higher ed handbooks, including some where consent essentially means you need affirmative consent along every step of the way in a romantic or sexual interaction. And so, for instance, I don't know if this is still the current iteration, but a previous iteration of Yale's student handbook on consent could be interpreted to say that, long-term couple in a bed, one is asleep, the other kisses the partner goodnight, and then falls asleep, and that lacked consent. And of course, in what world is campus security or law enforcement going to bother with this? That's not going to happen. But there are policies where if they are construed very literally, that is actually, it's an incredibly high standard of consent, much higher than that which is required in any criminal code that I'm familiar with.
Yeah, I would note, actually, if you don't mind me kind of chiming in here, one of the changes this past June to Dartmouth policy was actually the definition of consent. And so the proposed policy, which now I believe is the policy, defines consent as, quote, clear and unambiguous agreement expressed in mutually understandable words or actions to engage in a particular activity. Now, the dean of students at the time, this is back in June, said this definition doesn't necessarily mark a policy change. Rather, the clarification aims to emphasize the affirmative aspect of consent. And here's what the dean was quoted as saying. And by the way, I should know, this is the Dartmouth newspaper, so giving a shout out because there's a reporter in the audience from the Dartmouth paper. Quote, "It's not a question of did you hear no, I think it's really a question of how did you hear yes." And that was how the dean of students characterized the consent language change, but she characterized it obviously as not a policy change. The striped dress.
What is the legal standing of a contract enabling an institution to read an individual's emails? As I currently understand it, Dartmouth College is able to read every email sent or received by a at dartmouth.edu email address, including just about every email I've sent over the last 2 years. So what's the legality of a contract including that clause?
Well, you go ahead.
Okay. I'm not familiar with Dartmouth's acceptable use policies in particular, but broadly speaking, educational institutions' acceptable use policies do tend to cast a pretty broad net for the ability to monitor at the institution's discretion, sometimes with a set of criteria, sometimes not, communications that are sent over their internet, wireless, or other devices. So it usually casts a pretty broad net. I am not aware, and Judith may know more about this than I do, I'm not aware of any law that would say that Dartmouth or another private institution of higher learning, as long as its acceptable use policy is appropriately, publicized and students have notice of it as part of the contract that they essentially enter into as part of the student handbook. As a faculty or staff member, we also, at higher ed institutions have handbooks that contain also very broad acceptable use policies. I don't believe that higher ed institutions make it a practice to do that kind of mass email monitoring. I know Harvard got smacked around a little bit when I was when I was on faculty there. I don't believe they were interested in my emails, but they, there are a lot of conventions and values at play that I would say usually stay the university's hand before going that route. So I can turn that over to Judith.
Usually a question like this about using the server of a private institution, the answer is get Gmail.
Yeah.
But also, a number of institutions have outsourced their student email functions to Google. And there's been a lot of difficulty with Google, I understand, because Google isn't interested in FERPA. That is what I've been told. But that's another issue.
I think they're getting more
because-
interested in it.
I
but
hope
yeah.
so. I hope so.
Yeah.
Because
They're
it really, I mean, if Google is managing student email, then the university's ability to just play around with it is amazingly limited, because Google would have to let them do it. So that's another factor in this whole thing. I don't know if Dartmouth uses Google, but
Interesting. Well,
So that's the Family Educational Rights and Privacy Act that I was talking about earlier, which is the one that says that schools can't disclose education records generally without consent. Yeah,
It's
no
an
problem.
acronym.
we have a question in the turquoise. Okay. And then we'll go to the corner.
So I've heard a lot of gendered pronouns being thrown around. So first of all, are we making the assumption that the complainant is always going to be a woman and the respondent is always going to be a man? Or how does Title IX play into, because Title IX is about no discrimination or denial of educational opportunity on the basis of sex. So how does this work when the complainant is not a woman?
I think the guidance that came out in spring made it clear that OCR believes that gender discrimination can happen with both genders. And in fact, there's a case at Brandeis now involving 2 men that is clearly being treated like a Title IX case.
We'll go to the corner, blue shirt.
I was just going to talk about the question previous about the emails. I was going to ask a similar question, but I found the actual policy, and it says that college officials may access information to administer this or other Dartmouth policies. That's paraphrased, but that's basically what it is. And that is pretty much as broad of a net as you can
Yes.
cast.
It is.
So
Yes, it is.
I was wondering, is Gmail the only way that students can try to avoid that? And there's definitely no explicit notice given.
Right.
So I don't know if that is legal, or if I'm just not exactly sure what the constitutional stance on that would be if there's no notice to
Well,
students.
as that's a great question. As going back to the point George made at the outset, Dartmouth is not a state actor. They are a private institution, so the Constitution does not apply to them. And so if they've given you notice that that's their acceptable use policy, you probably clicked on something in order to create an account and log into the server, or you signed something saying you got the student handbook. So they're, as far as I'm aware, on firm legal terrain there. I think Judith's point is very well taken, that if you are looking for additional layers of privacy in terms of your communications, be they on email, Facebook, what have you, then use a provider that does not, that's not the Dartmouth.edu. Make sure that your privacy settings on Facebook, et cetera, are set as high as you can make them, keeping in mind that Facebook and other companies can change those policies at any time. So please, please, please don't put pictures of yourself doing illegal things on there, because rest
will find
assured,
out,
Chris
too.
will find, somebody will find it. Even if you think that you're limited to friends, you're going to get a friend of a friend who gets someone to log in, and you just don't want to be responsible for putting images of yourself up there.
Judith, this is as simple as Dartmouth saying, if you don't like our policies, don't come here. I mean, this is, or is there any claim that a student can make under contract law that, there wasn't proper notice provided?
I haven't seen a lot of cases on
Yeah.
it. Leah would know more than I do about that, but.
And I do think that there's a lot of room, though, as members of an educational community, to have robust discussion about electronic information and privacy policies, as we're doing right now. And those discussions can certainly be continued with, let's say, a dean of students or an IT department, or with faculty members who are invested in this, because there are certainly ways as members of a community where it doesn't have to be just take it or leave it. Obviously, students have a very powerful voice. And so in terms of getting, sort of more education on these issues, I would encourage you to take a look at the Berkman Center website, so cyber, cyber.law.harvard.edu. Electronic Frontier Foundation also does really excellent work around student privacy issues, and there's some other organizations out there as well that can help you think about whom you might contact in an institution and how you might express your concerns about the values that are implicated in those kinds of acceptable use policies in terms of what they say about level of trust or lack thereof.
We have time for one last question, but I want to propose a question kind of along this grounds, which is, if a school is engaging in an investigation that will ultimately lead in a potential school discipline proceeding, you use the Dartmouth EDU email account. Can they just go and look at your emails?
Yeah.
Yes, as far as I'm
Okay.
aware. Yeah.
And we've had criminal cases where the person at safety and security, they were just sitting there kind of reading people's emails and
That's
came across
interesting.
a couple of juicy ones that
Oh, dear.
Wow.
led to a criminal investigation. And
That's interesting.
So, yeah.
One last question, if there is, last question right here.
As a member of the Hanover community, could you let us know, I often wonder, what right legally do the Hanover or state police have to go into a fraternity or sorority where everybody's drinking, and that 90% of the people in there are under age 21 and breaking New Hampshire law by being served alcohol? And it seems this is going on, whether it's at Keene State or at Dartmouth or any other school in New Hampshire, where there's a state law, and that law, to me, is being broken. And I'm curious, who does what about it? I sat in at the summit on sexual assault on Monday, and there was a Dartmouth security guard there. So I asked him this question. He says, "Oh, well, we go in and we go to these parties, and if we see somebody under 21 drinking, we ask them their name, we write it down on a pad of paper, and then at the end of the week, we send that pad of paper of names to the dean, and we have no idea what happens after that."
So that's a great question. In answering that, panel, I would see if you can chime in on to what extent does public law enforcement, sworn officers, have the authority to enter a private campus?
They would have to, the fraternity scenario, they would, if they showed up and the fraternity brothers said, "No, you're not coming in," in other words, they didn't give them consent to come in, they would have to have then at that point gathered enough information to develop probable cause to go to a judge to get a warrant to allow them to go into the building to either seize the alcohol if everybody's underage, or to look for evidence of underage drinking. So
Is that difficult?
it's not. It doesn't happen quite frequently. I mean, because most of the time, particularly in Keene, everybody's in the city. They're just walking around the city, and so there's plenty of underage drinking that they can just nab off the street. And the fraternity environment isn't the same at Keene State as it is up here. If it became a real problem, I think the Hanover police would probably then become more invested in it. I can't obviously speak for them.
But there are every year probably, 6 to 10 prosecutions of fraternities and sororities in Hanover for underage drinking. Beyond that, it's a political question of resource allocation probably, and prosecutorial, resources. That's probably what I'm not a prosecutor, but I'm certainly an observer of the process. But there are prosecutions, and there are regular prosecutions of fraternities.
Well, with that, I want to thank our panelists so much for giving us their time and for putting together a great presentation. Let's give a round of applause. So I want to thank everyone again for coming. Another plug for the NHCLU. We have a website, nhclu.org. You can see all the litigation and advocacy work that we're doing. There's no one else in the state doing the type of work that the NHCLU is doing. So I would very much encourage you to check our website. We update it every week. Thank you so much for coming.